3, 2, 1.
Recording in progress.
Good afternoon, people. Good afternoon, ladies and gentlemen. My name is Kevin Malunga. I am the head of Regenesis Law School, which is a new kid on the block, fully accredited by the Council of Higher Education and SAQA for the purpose of training lawyers in South Africa. And we have, in recent times, established a webinar series that aims to bring the practice of law to the community and real practical issues. And I just want to quickly highlight that today's topic will be on criminal law and entitled Know Your Rights. So my very capable co-host, co-pilot, will be Advocate Ilya Mwanawina, who is a law lecturer at the Regenesis School of Law and also a former professor at Northwest University. He's a practicing advocate with chambers at Dumanokwe, and of course, he has a lot of experience in consulting, practice, academia, and has, obtained a lot of training from various esteemed entities around the world, and is a very, established academic with a lot of publications, book chapters, journal articles. But of course, right now he is here as one of our own, hosting this particular. I don't know if you can see him, if you can see his face. Somehow he seems to have vanished.
Oh no, I'm still here, Kevin.
Okay, thanks, Ilya. Yes, so he will be co-hosting this, and of course, my face or his may appear at any given point in time. We are doing this together, so this is on criminal law, and then of course, next we have Advocate James Grant, also Dr. James Grant, who is. He is also a psychologist, by the way, by training, but he also happens to hold a PhD in law. So I think that's probably a very good arsenal for criminal law skills. I don't know if his face can also come up. I don't have the button for that. If somehow James can.
Hi, I think I'm
yes.
here. Hi, everybody.
Oh, yes. And
You got me.
James has had a lot of experience in fact, he lives and breathes criminal law. He's not a criminal, but he lives and breathes criminal law. He's very passionate about this. Has over 16 accredited publications to his name. He assisted the state in its appeal against the culpable homicide conviction of Oscar Pistorius. I hope I can have that correct, James, because that's the profile that I received.
Yeah.
And he did his pupillage at the Johannesburg Society of Advocates and started practice in 2015. And of course, he's also acted as a judge of the High Court for 2 terms in the Gauteng local division. And in Johannesburg, and of course, returned to practice in September 2019. He immigrated to Denmark in 2022, where he continues to practice, which is why I was wondering is where the +45 phone number is.
That's it. Yeah.
Yes, and of course, so he runs his practice remotely, drafting legal papers and writing legal opinions. We should have called you to our last webinar on digital practicing in the digital age, because it actually,
Yep.
This is actually, you're doing it in the most practical way. We can, it's the reality of 2023 that
Yes.
we hardly sit in a room together.
Yeah.
Yes, and then of course, Yeah, it's amazing. It's amazing. Absolutely amazing.
Yeah,
And
it's
then,
amazing. I can practice law from Denmark in South Africa.
Yeah.
Yeah.
Absolutely amazing. Yeah. Then we have Ms. Lungelo Mukwena. I don't know if we can also see her face.
I am here. Hi. I'm not sure if you can hear me.
Yes,
We can.
we can.
Thank you so much for the invitation. I already am on it. What I'm going to say next is actually going to reveal how junior I am on this panel. But I come from the hands of Professor James Grant.
I'm so sorry.
I'm another victim of yours. So I was a part of
Apologies.
Wits Law School. The year was 2015. It's okay. It's all right. We made it. I'm here now. So.
Wow.
There is nothing like junior in this context, Lungelo. We want all the different experiences.
Got it.
We also have students who have logged on, who are watching this and who will contribute. So and Lungelo is an admitted attorney, and once you are in, you are in. Huh?
For life.
You know, an 8-year-old disbarred attorney is far more junior. He's not an attorney. You are an attorney. So that's how it works.
Yeah.
So, and she has, as she has indicated, obtained her LLB from Wits University School of Law and admitted recently as an attorney of the High Court and specialized in criminal law of evictions, family law, drafting contracts, etc., and general litigation. And she's also worked as a presenter for YFM. So, you know, you've got all these diverse backgrounds. And then, of course, Mr. Lee, please help me, Lee, to pronounce your surname properly, because I think it's rude in terms of African culture to pronounce someone's surname wrong. How do you pronounce your name? Is it Binnaman or how do you pronounce it? Lee? Is Lee here? Has Lee fallen off?
I can see his profile, but he's still muted, and also the video is muted.
Okay, because we were talking to him earlier on. It's fine. It's fine. When he is able to come back, we will.
Just hold on. I can see his video. He's trying to speak.
Oh, he flashed on and off again.
Yes.
He did mention that load shedding is going to be.
Hi.
Can you hear me?
Yes.
Oh, Lee, you're back. Yes, I was
Yes.
saying, please help me to pronounce your surname properly.
It's Binnaman.
So I tried. So Mr. Lee Binnaman is a partner at Schindler's Attorneys, and I believe that's in Rosebank.
No, we're currently based in Melrose Arch.
Melrose Arch. And he obtained his BA from Rao and his LLB from UJ, but that's the same institution for the younger amongst us, pre-merger and post-merger. And his areas of expertise include criminal law, commercial law, and general litigation. He was admitted as an attorney of the High Court of South Africa in May 2009, and has since been involved in a number of magistrates court and high court trial actions involving various fields of law, including administrative, commercial, construction, insolvency law, and of course, he has a general practice, competent litigator. So welcome, Lee. It's a pleasure to have your experience with us here.
Thank you very much, Kevin. It's lovely to be here. I really appreciate you inviting me to participate today.
Yes, and lastly but not least, I hope I'm not missing, is Stephen here? I'm sure Stephen is here.
Yes.
But lastly, but
I
is
am
Stephen here?
I am here. Can you
Okay,
hear me?
okay. Stephen, yeah, because earlier on I couldn't see you.
I don't know if you can see me at the moment.
Yes, no video, but audio.
My camera is on, and it is working. I checked in another app. But be that as it may, it's not particularly important.
The beauty
Okay,
of
now we'll work on that as we proceed, Stephen. Sorry about that. But Stephen is a distinguished attorney and founder of SGM Law, and he's, as I said, a seasoned courtroom professional, having worked on various high-profile cases for a number of clients. He has an LLB from UNISA, certificate in macroeconomics, and a higher certificate in banking and law, finance law from FITS, and also very much involved in multiple litigation. I don't know if Graham is here. Kerr Phillips
So Graham Kerr Phillips will be joining me by the same link shortly. It just so happened that we were called into an urgent application today. I'm actually sitting now in an unused courtroom. And
okay, yeah. So when Graham joins, for the sake of knowing who he is and what he does, he was admitted as an advocate in 1991, and he joined the Johannesburg Bar in July 1995. And I've had the opportunity to engage with both Stephen and Graham and pleasant interactions. And he presently read for the degrees. He has read for the degrees of BA, LLB, HDIP Labor Law, and is presently reading for his Masters in Company Law and Banking Law. And of course, prior to joining the bar, he was a member of Office of the then Attorney General. And while in such employment, he specialized in the prosecution of commercial white-collar crime. And since 1995, he has further expanded his practice in criminal law from a defense perspective and has developed commercial, labor, and family law litigation practice. So that's Graham. And then last but not least is Ms. Ndabiseng. I'll save the best for last, actually. Ndabiseng Dubazana is the owner of Dubazana Attorneys. Her firm is based in Randburg, Johannesburg, and her practice deals with family law, labor law, general civil litigation, criminal law, and deceased estates. And she was well known for her guest appearances on Power FM, ENCA, SABC, where she talks about high-profile cases and pertinent legal issues. She keeps everyone informed as to what's going on. And she served as a legal advisor and in-house counsel and will advise various aspects of law ranging from drafting of contracts, clients, assisting insurance, labor, divorce matters, and criminal matters. And she served her articles with Legal Aid South Africa and dealt with various matters assisting those in need. So, yes, so I will get the ball rolling, ladies and gentlemen. And of course, welcome to our audience who consists of people in practice, members of the public, students, and we really want this to make this worth your while. If my angle is a bit skewed, it's because I'm using my tablet to avoid load shedding. James has probably forgotten about those kind of things, but it's make sure that I don't bump off at any point in time. So the first question, and please, anyone is free to take this. Many South Africans find themselves clueless when being pulled over in or at a roadblock. What should you advise members of the public to do when being pulled over? And this happens all the time. Almost every weekend, I'm pulled over. So any takers on this one? Anyone who wants to get it?
I'm happy to address this.
Thanks.
This, Kevin, if you like.
Thanks, Steve.
So I think the important thing at this stage is to consider that there is a distinction between what you call the roadblock and what then is also what most of us fall victim to, which is colloquially considered a roadside check. So a roadblock is when you'll find yourself traveling in any direction to any particular point of destination, and there's a formal blockage of traffic and a funneling of said traffic, generally by the JMPD, and they tend to stop and do general kind of preliminary inspections of the vehicles. So a roadside check is in those instances where you are just pulled over, where there isn't something formal that's been set up, where the flow of traffic hasn't necessarily been interrupted. Now, roadblocks generally contain proper signage, traffic cones, barriers, markings, and are regulated in terms of the South African Police Services Act and the National Road Traffic. Ordinarily, these are instances where the JMPD and the various other law enforcement divisions will do general inspection. So practically speaking, we've all been involved in one of these. They'll stop you. First and foremost, what they'll do is they'll make an inquiry of you as to a driver's license, and thereafter they'll check, as a preliminary thing, they'll check your licenses. Now, they do this to determine whether you are lawfully entitled to be on the road as an authorized driver by way of a valid driver's license. Alternatively, to check your license disc on your vehicle to determine whether or not your disc is up to date and your vehicle is actually lawfully entitled to be on the road. So the way the question has been structured is, what do you do in a situation where, for example, you've been pulled over on a roadblock? You practically speaking, and as a general piece of advice, which I like to give most, you generally want to cooperate as much as possible in these kinds of circumstances. So they'll pull you over, and the first question will always be, can I have a driver's license? You'll find that what they'll do is they'll engage you directly in conversation. And they tend to do this as a preliminary kind of investigation tactic to determine whether or not you've imbibed any alcohol, and to try and get a feel from you about whether or not you ought to be behind the wheel of a vehicle. So I suggest and I recommend that when they arrive, you have your driver's license ready, you ensure that your license is made up, because in circumstances where your driver's license has expired, alternatively where the vehicle in and of itself is not permitted to be on the road because the license fees have not been paid, it could potentially lead to further interrogation and investigation by the relevant enforcement officer. But generally, the advice here is just be respectful, be cooperative. They want your driver's license, so they ask you to produce something. You make it available to them, and let them conduct their preliminary investigation or inspection of you and your vehicle without any kind of hitch or hiccup. To the extent that you become difficult or uncooperative with them, they will rely on a suspicion that you're trying to hide something, and they'll tend to detain you for longer than you should. These roadblocks also tend to, and I think we've all seen it, there'll be a big vehicle, like a big white JMPD marked vehicle, which is parked next to the road. And when you see one of these, they're normally scanning your license plate, and they're doing this to determine whether or not you've got any outstanding fines or infringements, alternatively any warrants which may have been issued as against you or the vehicle in respect of any kind of traffic offences. So the general advice here is cooperate, do what you need to do, and cooperate as much as possible so that you can just be on your way. If your license is valid and your license disc is paid up, and there is no other reason to detain or question you on anything further, your breath doesn't smell like liquor, or there isn't something suspicious which might be contained in the back of your vehicle, a body or something of the sort, they're generally just going to let you go on your way. So the general advice is cooperate.
Sure. Lee, I think one thing I just want to maybe seek clarification from, which a lot of people raise, and in my previous life I had to also do investigations against excesses by police officials, whether at Metro Cops or provincial forces, the national or SAPs and so forth. The question then is, how do you deal with a situation where you feel that a particular officer is crossing the line in terms of your rights and your for example, they want cold drink, they want it as they call, they want a bribe, or they are being excessive.
So, given that it's a very practical kind of situation that you've sketched here for us this afternoon, the police or the enforcement officers can tend to be a bit difficult in circumstances where they're seeking a cold drink or a bribe, as we know. The advice is always to avoid engaging in anything like that. If they're saying to you, you'll often hear, "Oh, you've got this infringement, your license is expired. I should give you a fine." Or we can sort this out. There'll be a spot fine payable, as they like to say. That's when they're trying to elicit some sort of bribe from you. Now, we're all aware of the Prevention of Corrupt Activities Act and the issues that it canvasses there as relating to corruption. And I think what a lot of people need to understand is whether it's a 20 rand so that you can go on your way, or whether it's a 2 million rand so that you can secure a tender, corruption is corruption. It's it's the tender of an undue performance to an officer in circumstances with a view to avoiding some kind of prosecution. So the advice is always to avoid that. If he's saying to you, I have to issue you with a fine, I would suggest what you do is you tell him to write the fine out, let him do so. And when the fine has been issued to you, there are a number of avenues available to you to, in fact, deal with that fine. So you can approach the relevant traffic departments, you can reduce the level of the fine, you can submit representations to have the fine quashed. There are a number of avenues available to you which fall within the parameters. So when dealing with someone who's trying to push you to potentially pay some sort of gratuity, my advice is to avoid that at all costs. Tell him to issue the fine and then take the necessary lawful steps to deal with the fine. If it's been issued in incorrect circumstances, then you have the availability to approach either the traffic department or the National Prosecuting Authority with the assistance of a legal representative to deal with that eventuality.
Kevin,
Oh, excellent. Yes.
if I
Please go
may,
ahead, Ilya.
thank you very much, Kevin. If I may put this to our panelists, I'm looking at the statistics of how much South African breweries contributed to the economy. And one of the statistics that are coming up is that in 2010, SAB contributed 58.56 billion to the South African economy. So I have no doubt that either on the panel or the people listening in, have consumed alcohol on one or more occasions.
Yes.
I think there might be an interest to know what the citizens' position is in relation to the drawing of blood or breathalyzers at these checkpoints and roadblocks. How can we remain law-abiding citizens?
Yeah. Lee, go for it.
Do you want to carry on?
I'm happy to. I don't want to.
And or anyone else who's not at all.
So you guys would all have been made aware of a system they implemented some years ago. It was a breathalyzer system which was implemented by a company by the name of Draeger. Now, what they were trying to do with these breathalyzer systems was do away with this backlog that sits at the forensic laboratories governed by the South African Police Services. Ordinarily, when blood is drawn, it's almost a guarantee that matter will not make its way onto a court roll despite your arrest. So they tried to circumvent this by prosecuting on the back of a breath alcohol. There was some leading case, I think it was in the Western Cape, where that Draeger system was in fact found to be entirely unreliable and dependent on a number of different factors. Whether you eat and exercised, whether you were a smoker, diabetic, there were a number of influencing factors which did away with the credibility of a prosecution on the strength of the breathalyzer results. So practically speaking, what tends to happen is the traffic officer will breathalyze you and will use that almost as an interim measure to determine whether or not you should be detained and then taken for blood. So, and it escapes me now, but there is I think it's 0.01, I forget the level in respect of the Draeger. But if you do blow into the breathalyzer, and again, the point is to cooperate as much as possible so as to avoid any difficulty with the enforcement officer. If the Draeger or the breathalyzer system does register you as being in excess of that which would be acceptable pursuant to those regulations, then they've got reasonable cause then to detain you, and they will then take the further steps to deal with a blood drawing and then send the blood off for testing with a view to prosecuting you. So first and foremost, don't get behind the wheel of a vehicle, even if you've had one beer. I know a lot of us like to think, well, I've had one or two drinks, but I've also had something to eat and it's been a while. The advice is avoid the risk at all costs because you never know what the situation is going to be. And to be detained overnight or for more than one night, which the police like to do over a weekend, on a drunk driving charge it's really not worth the time, the money that you're ultimately going to spend on defense to get a bail application done. So rather don't get behind the wheel if you've been drinking. There's a number of these drive me home services, Uber's available, and but in circumstances where they are going to now take your blood, they've obviously come to a decision that you have been drinking, that you are under the influence of alcohol, and you've been behind the vehicle or behind the wheel of a car. In those circumstances, they'll detain you, take you to the district surgeon, and the district surgeon will then draw blood. Now they must do this within a period of 4 hours from the time of your detention, failing which those blood results will not be admissible and will not be deemed to be accurate. So they are going to try and expedite that. Trying to resist the taking of blood and enforcing what you would call your constitutional rights to bodily integrity, really, practically speaking, are not going to be of any assistance to you. They are ultimately going to take the blood results. So even in those circumstances, it's best just to cooperate and to see whether the forensics laboratories are in a position to render a result that takes you over the 0.05 limit of alcohol in the bloodstream.
Thank you very much.
Thank you so much. You recall the famous case of Judge Motata, right? But anyway, please proceed. Ila, you can proceed.
I noticed Ntabi Singh's hand is up. Ntabi Singh?
Thank you. I wanted to add to what Lee was saying. The breathalyzer test, they ended up making it that if the alcohol in your breath is up to 0.39, they, for whatever reason, increased it, which doesn't make sense to me. But
Yes, you're right. It was 0.24 originally. That's right.
Yeah. And then they increased it to 0.39. And at that stage, then they will do everything that you've already discussed, detain you, etc., etc. And here's the thing about what you just mentioned about your constitutional rights to say you can't draw blood without my consent. The Criminal Procedure Act actually covers that. There is, unfortunately, the section escapes me right now, but the Criminal Procedure Act states that the court will allow for the drawing or the taking of certain human tissue without the consent of the accused if it is within the interest of justice. So trying to bring in the issue of, my constitutional rights, you can't take my blood without my consent and all those things doesn't work for you because the Criminal Procedure Act covers that, right? And then over and above that happening, when the blood does eventually come back, 90% of the time it comes back 3-4 years later. So, it ends up being a pending matter on your SAP 69s. So in the event you're going to apply for a job or you're going to fly overseas, whatever the case may be, when your fingerprints are then taken, it shows as a pending matter, because as long as the blood alcohol is not back yet, it means that matter hasn't proceeded, nothing has been withdrawn, and you were charged. Remember, you filled in that rights sheet at the prison, at the police station when you were arrested, and then you either pay a certain amount of police bail or actual bail application is done on a Monday, etc., etc. It appears as a pending matter. So I agree 100% with Lee when he says just avoid driving once you've consumed even one glass and one can of alcohol. And the blood alcohol limit, if you're holding a PDP license, it becomes even more tighter and stricter for you, because according to Section 65 of the National Road Traffic Act, you should have 0.02 alcohol in your blood. So you see, it's even stricter than that. And then if it is over and above that, and then the matter does get to the court, and somehow representations don't work out, and then the matter, you are found guilty, you have a high chance of losing your PDP license, which means if your work is transporting people, now you don't have a source of income. So I just wanted to say that.
Okay, thanks. Thanks. And while we're there, thanks a lot. There's a question from Sumaya in the chat box who says, "What if you are stopped and by police officers and you don't feel safe?" I suppose she's referring to these fake officers who hijack people and so forth. So she's saying, "What are your options under those circumstances?"
Yeah, I actually did see that question, and I think it's a good question. The way it was phrased was, if the individual that's being pulled over and interrogated and searched is a female and they don't feel safe. So I think that's a nice category to work in. You are within your rights, look, depending on whether it's, and this would be in the context of a roadblock or one of those normal pullovers rather than a drunk driving incident. If you've been drinking and they've breathalyzed you, whether you're female or not, they have to take the necessary steps. I think we must accept that as a given. But in circumstances where it's one of these roadside stops and you don't feel safe, the police are trying to pull you over, you can indicate, and what you suggest you do is that you indicate to them that you're more than happy to cooperate with them, you are tendering your cooperation, but you want to do it at the nearest police station, and you must make your way into the nearest police station so that whatever actions are undertaken by the enforcement officer are done in a circumstance where you would feel safer. If there isn't a near police station, my recommendation to you would be to find a more public environment where there are potentially people, private security entity which might be around, just to ensure that whatever your concerns and your fears are might be allayed by somebody else witnessing the event. You know, in today's day and age, everybody's cell phone appears to be their best friend. So when there's an incident,
Absolutely.
somebody's certainly going to record it, and it's going to put you in a position where you would have a greater ability to either defend a case, alternatively prosecute a case against the police for an unlawful action that they may have taken against you.
Oh, thank you so much. Okay, I think that's great. We've still got quite a few questions to go to, and I think let me go to the next one, which is, and anyone can take this one. And what should every citizen know in terms of their rights when they are arrested and detained by police? Anyone wants to? Maybe Dr. Grant or anyone?
Tabaseng was about to speak. Won't interfere.
Okay. So what I've experienced, especially in my time in legal aid, what happens is that a lot of our people in our country really don't know their rights when it comes to this situation, right? So they sometimes want to fight the arrest, which now adds another charge, which is resisting arrest, and then it ends up being a whole mess. So when you are now arrested, you are now in the police station, Section 35 of the Constitution automatically kicks in. Actually, what I found out, it was very interesting to find out during preparation for trial a few years ago, maybe 5 years ago, and I came across a constitutional court matter back when it was still the interim constitution, and it was deemed that Section 35 also applies to people who are suspected of having committed a crime, not just arrested people. So which means that at the moment that the police stop you and inform you that they are arresting you for X charge, at that moment they have to read you your rights, basically inform you what your rights are under Section 35 before you open your mouth and inform them about anything. Right? So when I discovered that in preparation for trial, lucky for me, I was still very wet behind the ears that time, and the matter was part heard. So when I discovered this particular case, I then put it to the SAPS member who was in the dock, 20 years experience, and then put this information to him. And then he informed me that in order for him to get the things that were stolen and attribute the case to the accused, he made the accused give him that information. Then I asked, did you do this before or after you informed him of his rights? And then he answered and he said, at the police station, this is what happens all the time, at the police station, when I made him fill in the rights sheet, that red and black piece of paper, that's when I informed him of his rights. I informed him, I'm like, everything that all the information that you got and from the accused person at the time before you read him his rights, it's all inadmissible. Are you aware of that? It is even unconstitutional because it cannot be used against the accused. He wasn't aware. And as a result, it means that as soon as you are detained, if the SAPS does not inform you what your rights are, what will happen should you speak without an attorney present, that information will be used against you in a court of law, and it will be used to continue on investigations, and that can be attached to you. If that information is not given to you prior to you being taken to the police station, please be aware that what is happening at that moment does not fall within the ambit of your constitutional rights being protected.
Thank you, Tabaseng. James, you want to?
Yeah, Kevin, I just want to add something of a practical nature, which applies to this situation and to the previous situation of being stopped at the side of the road or at a roadblock. And the practical advice is record everything. Nowadays, cell phones are prolific. They're able to, at the very least, record audio. Set your cell phone up so that you can very quickly get to a voice recording app and switch it over. If you see that you're about to be pulled over, switch it over to recording audio at the very least and leave it running for as long as you possibly can during the engagement with the police. That will be invaluable evidence going forward. And another bit of practical advice is if you are able to get a dash cam, they are incredibly powerful devices. They record the situation. They record generally. They capture the identity of the officer who will be approaching you. And again, try to leave that device running for as long as you can. There are devices which are specifically designed to be able to be set to continue to run even though you switch your car off. Get one of them. These devices, and so the video and the audio become invaluable evidence at trial, if that's where you're going.
Yes. Now, James, I couldn't agree with you more. Yesterday, I was reading a very interesting article that actually backs up what you're saying, but it's not in the context of the roads. It's another alleged crime, which is an attempted rape by the head of the Pan-African Parliament, where the victim recorded him, as she was in his hotel room, and everything he was saying, all his propositions, and especially for a person of this stature, were all so. Basically, I from what I see, for me, that seems like a slam dunk case, as the Americans call it, because she's got the audio. So unless it will take a miracle for a judge to discard that. So yes.
Kevin, and it's just an important point also that people aren't often aware of, is that you are entirely permitted to record audio and video of a engagement in which you are a party. In other words, if somebody comes up to you and you're in a conversation with somebody, you're allowed to record that conversation. What you're not allowed to do is to record the conversation of other third parties where you are not a party to that conversation. So you don't need to ask anybody for permission to record a conversation.
Absolutely.
Thank you very much, Kevin.
Can I come in?
Yeah, please go ahead.
Sorry, I'm interrupting there.
Please go ahead.
So I just wanted to make a response to both Nthabiseng and to James. Just following on section 35, the rights that you need to always bear in mind when you are, let's say, being arrested and detained. 35(2)(a) of the Constitution. It is incumbent on the arresting or detaining officer to inform you of the reason that you are being arrested. They must tell you. They can't simply take you into custody and not give you an explanation as to why they are taking you into custody. So that is fundamental. And then for me, the most important in my years of criminal work, it's one thing that was instilled in me very, very clearly by my mentors where I did my articles. Your constitutional right to remain silent is absolutely fundamental in any engagement where you are being accused of an offense. And Nthabiseng correctly points out that what the police will try and do is elicit so-called admissions from you in respect of whatever offense it is that they intend to charge you with. And once you've been informed of the charge and they've taken the necessary procedural steps, to the extent that you then start making any admissions to the arresting officer in whatever format, whether you're trying to negotiate your release or you're trying to convince him that it wasn't you, whatever admissions you make to him will then be admissible against you in your prosecution. So we always, when we attended a matter where somebody's being arrested and being detained, you're presented with a document called a warning statement. It's a form which this is what the police have done now to ensure that they purportedly an attempt to try and comply with your constitutional rights. In that document, they have to identify themselves, they have to tell you what it is that they intend to charge you with, and then they have afford you an opportunity, in and amongst other things, to make a statement, to give a version of events in relation to the offence. And this is easier to conceptualize when it's not a situation being pulled over and drunk driving. Let's say, for example, there's an investigation into you growing an inordinate amount of marijuana in your property. And they've arrived there and they're taking you into custody for possession of drugs. That will be the charge, or potentially dealing. They will put questions to you, and you are entitled to refuse to answer those questions. So you exercise your right to remain silent. You make no statements about the charges that are put to you. That is the golden rule. You are also entitled to refuse to answer any questions, to refuse to make any pointings out. Generally, in the more capital type offences, for example, where an individual is being accused of serial murder and they can't find the bodies, or where they ask him to try and figure out where certain of the offences may have taken place. It is within the realms of the police to put you in the back of a vehicle and to drive you around, and to tell you or to coerce you into pointing out where evidence may exist which they can use for prosecution, alternatively where offences may have taken place. So you can lawfully refuse to engage in any answering of questions, making any pointings out.
So, Lee, can I just hold your tongue while you are there, because
Sure.
your angle is going into my next question, which is what should every client have prepared for their attorney when they're faced with possible criminal charges? So anyone in the panel can go for it, but you are going in that direction.
Yes, well, I'm happy to hand over to anybody, but to have prepared for your attorney in these circumstances, it's really simply who you are. Regrettably, in this institution, it's a situation where you are going to have to be able to place that attorney in funds. So you must be in a position to formally mandate your attorney before you start consulting with him to ensure that you fall within the realms of privilege. And then you're in a position now to make whatever necessary disclosures are relevant. So what you have ready is really just identity of who you are, the ability to properly mandate the attorney to come and assist you, and I would say contact particulars if you are going to be detained for close family members so that they can be contacted to assist you with whatever the position might be regarding your detention, bail. And when a consultation then takes place, the necessary information needs to be disclosed to the attorney in order to comply with Section 60 of the Criminal Procedure Act with a view to doing a proper bail application and securing your release.
Yes. And while we're there, what is required to retain you as the attorney? Over weekends, especially, you get a lot of these drunk driving, immigration, or all sorts of other infringement where people are locked up over the weekend, and they say, please get me a lawyer. So now the question is, how does one get Lee to agree to that? Well?
So you sign a formal mandate, a letter of engagement where you agree and you enter into, I mean, for lack of a better terminology, you enter into a contract with the attorney. This doesn't necessarily in those circumstances need to be in writing, but you will at some point have to record in writing that you have formally mandated this individual to act on your behalf. And as attorneys and private practitioners, you will need to place the attorney in funds so that he can formally take steps to assist you.
Evan, if I can just come in here.
Yeah, please. James.
So it goes back to both the first two questions and then a little bit to what Lee has described now. And it's about when to speak and when to shut up, to put it bluntly. And the Constitution gives you the right to silence once, certainly upon arrest. And the general advice, I think, there are extreme exceptions to this, and they're not worth going into at this point. But it certainly seems to be good advice to say generally, the moment there's an indication that you are going to be put under arrest or that suspicions are being aroused, just be quiet. exercise your right to silence. And that's just to follow on what Lee said, which is that you have the right to silence. My point is exercise it. Be quiet. And you might come up against a police officer who then says, oh, you're being difficult or you're not cooperating. All you need to say is, no, with respect, sir or madam, I'm simply exercising my right to be quiet. And then the flip side of that, once you have mandated...
It's all in here, the Constitution.
Yeah, it's in there. But it's more, again, practical advice, if I may. Again, once you engage an attorney, speak and tell that attorney everything, and tell them the truth. I have had numerous cases where the individual has thought it fit to rather lie to the attorney, who then has to convey those instructions further on down the line to the advocate. The advocate is the one who goes to court and presents the case in court. And lies have a way of just falling apart. Let the experts deal with it. It can always be the case that once you tell the truth to the attorney can always say to you, listen, I am now conflicted. I've heard your story. Now I can tell you, you need to get a different attorney and you need to be quiet on these matters so that that attorney can represent you properly. But the first attorney you engage, tell that attorney the absolute truth. So again, be quiet to start with, and then open up and tell everything to the attorney once you get one.
Oh, absolutely.
If I may
Thanks for
come in.
Yes. Please go ahead.
You know,
Yes,
Advocate Grant, I'm in such agreement with you. The downside of exercising your right to silence, I think also I'm at an advantage because I've worked at Legal Aid for so long. The downside of it is that when accused persons actually choose to exercise that right, they get assaulted horribly. And then now we're dealing with the section 217, 218, 219 of the Criminal Procedure Act. And I don't know if any of you have been following the current case, Senzo Meyiwa, the witness that's currently being cross-examined. Under examination in chief, he actually detailed the kind of assaults that he received at the hands of the SAPS. And this is the reality that we have to deal with. And then when they come to us as attorneys, you have to now inform the court of this, because the warning statement that Lee was referring to was made under duress. And then now the police obviously are going to cover themselves to say, no such thing happened. And because they do it so well, that there are no bruises or injuries on the accused. I mean, trying to drown somebody, you're not going to get any bruises on that person, and all of those things. And they ensure that the clothes that you're wearing are removed from your body. So if you do happen to bleed, there's no proof on the clothes that you were wearing. That is the downside of the situation. And that's why people end up giving information in any event before their constitutional right has been read to them. So that is the practical, sad part about criminal law. It's very sad.
Thank you so much, Ndabaseng. Before I hand over to my colleague Ilya, Stephen Lungile, do you have anything to say regarding any of these questions that have been raised?
No, I think what I wanted to say was extended on by Lee, just essentially on the point of your right to silence. I know we are using a lot of legal jargon, and for someone who is not a legal person, listening to this, they're hearing section 19, section this, section that, it might confuse you. What Professor Grant said was correct. Just keep quiet. That's your first case in point. But those are just my contributions in respect to the question that you've just asked.
Thanks. It's Lungelo, not Lungile. Yeah. Thanks. Thank you very much, Lungelo. I don't know if there are any other input. But where is Mr. Advocate Manawina? Ilya, are you here?
Right.
Yeah, please take it away with the other questions.
Thank you very much, Kevin. Kevin, there's actually a question in the chat that relates to assault in situations where an accused person decides to exercise their right to remain silent. And I think to our panelists, we are all aware of Section 35 and the position of the law in relation to unconstitutionally obtained evidence. And I think what our audience might want to know is how difficult is it to prove that certain admissions or evidence was obtained after being assaulted? What's the threshold practically? It's an open question to any of the panelists. Stephen May, I see you are in court, so I suppose we will definitely get experience.
Yes.
Just to explain that, I happened to be called into an urgent today. So we're sort of coming up to the lunch break now, and I was able to sort of duck out and use an unused courtroom. Assured me that will be unused for the next.
So that's why you are there. I think our guys who are watching. Yeah.
So the question that was just asked relates to something that I wanted to add previously. So there's a crossover there. Ultimately, now this comes down to the art of the practitioner. And so I suppose that my answer is directed more towards practitioners and prospective practitioners who are studying at Regenesis. An arrest, oftentimes an arrest without a warrant happens so when the accused is caught red-handed. But more often than not, it is the result of contact from the SAPS or an investigation officer calling up a suspect and saying, I mean, this is the oldest trick in the book that they have, is they'll phone you up and say, look, these are more or less the charges. We just want to have a chat. And that is, in fact, a pretext for an arrest. After you've been lulled or into giving a version, not knowing that you're in fact about to be arrested. And what other panelists have said about the need to warn in terms of the Constitution and in terms of judges' rules, as soon as the person becomes a suspect, holds true here, but of course it doesn't happen in practice, and they like to find a way around that. So the first thing is insofar as exercising your right to remain silent, is to do it in such a way that benefits you the most, or your client the most. And that is ultimately, once you know as much about the case, once you know sufficient facts about the case that enable you to give an answer that attacks the state's case, but doesn't disclose your own version. And that really is the art of a practitioner. And insofar as a threshold for excluding inadmissibly obtained evidence, whether that's as a result of a beating or having failed to warn the accused or the suspect at that time before obtaining admissions or even a confession. How that's done, what are the prospects? What is the manner in which it's done? Is to attack the procedural steps that the police have taken. When a police officer arrests someone and reads them their rights in terms of judges' rules, or interviews them and questions them, having read them their rights, they're required to write it in their pocketbook and detail what they've done in their pocketbook. This then needs to be transcribed eventually into the investigation diary in the C section of the docket. Those two need to match up. And very often, usually when the police officers in question haven't done what they're required to do in terms of a warning or anything else, it doesn't match up. Insofar as a beating is concerned, when a person is booked into cells, there's the OB book and the cell registry, I can't remember what the proper name for it is, need to align as well. So when admissibility of documents of admissions and confessions is attacked in that way, and as I can't remember precisely who said this, forgive me, but mentioned a police officer with 20 years of experience of being cross-examined. Further and better disclosure of the pocketbook, the investigation diary, the cell registry, the OB book, and so on, because you would be able to, from that, trace the procedural pathway and be able to demonstrate from the lacunas in that procedural pathway that the proper procedural steps weren't taken. If the person entered the cell uninjured and left with injuries, oftentimes there's a mismatch, for example, and that is where you will begin to undermine the admissibility of unlawfully or illegally obtained evidence.
Awesome. Thanks. This is Stephen. Our students now can see what the courts look like. Thanks for that. Thanks for that.
Yeah, well, I can move it around. If you want, I can put hold my camera around. I've just had to pick up my whole laptop and do it. But I'm actually sitting in the stenographer's chair, so that I don't take the camera to the open door. But yeah.
So for those who've never been inside a courtroom, that's what it looks like. Thanks for that.
Hope you're not sitting in the accused position when you are in the courtroom.
I'm actually sitting in a stenographer's chair. So this is a civil court, so there isn't a dock as such. But
colleagues, I'm just trying to manage the time. We still have around 30 minutes to go. We have listened to Stephen's submissions as far as the reconciliation of the police docket, the investigation diary. It sounds like a very practical and almost forensic exercise to actually prove that there may have been instances where information was unconstitutionally obtained, and we'll deal with that in further detail, I think, in the future, Kevin. We might arrange a different session to go into that. But I would like to know from the panelists, in relation to the criminal law, criminal procedure area of practice that you all specialize in different capacities, what major developments, be it positive or negative, do you think the industry has undergone in the past few years that have impacted either your clients or your practice? With the profile event Regenesis keeps speaking into the session. If you could mute that.
No, it's fine. Marina, I'll send a message to our events manager to say, please proceed. Just proceed.
Colleagues, you may proceed.
I would just say that it's been my experience that criminal law progresses very, very slowly, so that I can't point to any particular momentous change in the law over the last few years. I don't know if my colleagues want to comment.
Yeah, I'll come in there, and I'm not sure if it's on point with the question. I think the one that stands out the most for me, and I think has been quite well publicized in the last, let's say, I think it's probably about 7 or 8 years ago, was the constitutional challenge in respect of the Drugs and Drug Trafficking Act. I think it's particularly Section 4, which was dealing with the decriminalization of marijuana. So it was quite prominent in the news at the time, and it emanated from what's known as the Prince case, where the use of marijuana was challenged initially on the premise that the accused person was a Rastafarian and it was in accordance with his religion, etc., that he be permitted to make use of cannabis. That then turned into a constitutional challenge which brought into question a lot of the scientific evidence into the effects of use and or abuse of marijuana or cannabis itself. So a few years ago, the Constitutional Court made a ruling that those sections which criminalize the personal use of marijuana have been found to be unconstitutional, and issued a directive to the legislature that an amendment to the Drug Trafficking Act ought to have taken place. To my knowledge, such amendment has not yet been effected, and it's actually left a bit of a lacuna in the law insofar as personal use. It's given rise to a number of questions. What does personal use constitute? Where can it be done? Because you're not permitted to make use of marijuana in public, but you are permitted to make use of certain amounts of marijuana in private. So the definition of privacy, where it can, how much you can be in possession of before you deemed to be committing an offence. So to my mind, the issue is yet to properly be resolved because the legislature has now failed to give effect to any kind of proper amendment of the legislation. And what you will find is that people are not really, well, people in the know are no longer being forced to make payments of admission of guilt fines so they're being caught in possession of a small amount of marijuana, which is quite clearly for personal use. The only ability that they currently have to prosecute now is if you fall within the realms of cultivation, produce, and or dealing, which are deemed events depending on the amount, i.e. the weight of the marijuana that's found in your possession. So as far as advancements are concerned, I'm not really sure whether it would be considered to be an advancement by each of the panelists or the students, but the amendments to the law, which I think have been quite significant in respect to criminal law, have been centered around the use of cannabis and obviously ancillary products.
Thank you very much. Have you said, please go ahead?
Lee, I wanted to find out from you if you've read on the recent, I forget the parties because the parties that are involved in this matter were minors. There's been a recent High Court case wherein the court ruled that we cannot find minors guilty of possession of dacha or marijuana because it impacts their life going forward. So it has been sent to refer to the Constitutional Court to confirm it. I thought about it as you were speaking on marijuana because if that is actually confirmed by the court, it means that minors, which is people under the age of 18, will not automatically go through the criminal justice system and be found guilty for possession of marijuana in any manner or form. Because if I recall the words that were used by the court in that ruling, they said that it is the folly of youth that leads our youth to use or experiment with marijuana. And as a result, finding them guilty because it appears on their previous convictions, their SAP-69s, as possession of drugs and not necessarily possession of marijuana or dacha. Therefore, the court is saying that we should not automatically place the kids through the criminal justice system. I found that to be interesting. So we'll wait to see if it eventually does get to the Constitutional Court for confirmation.
Yes, I mean, that's very interesting. I'm not as afraid with the constitutional consideration of that, but what that does give rise to, from a practical perspective, is what's known as diversion type programs. So you would have, we all would have experienced something known as a diversion program in respect of our clients. This is a system or a process that's been implemented initially to deal with assisting and alleviating court roles in circumstances where younger people were to be prosecuted for what could be considered to be minor type offences. And the ordinary course of process is that you're charged, for example, with the possession of marijuana, be it a single joint or a very small amount. And instead of being prosecuted, you would submit representation to a control or senior prosecutor in that court to suggest that your future as a young, prominent individual, their entire futures alive and available to them, ought not to be hindered by a prosecution with a potential conviction. It was ultimately extended to adult diversion, and these are practical terms which have been used, not necessarily the legal jargon, where in certain instances you could implore or call upon a prosecutor who's in a position to make a decision, such as a senior, to afford you an opportunity to avoid the criminal justice system by conducting what's known as a diversion course. I'll give you an example in the form of an assault case. Two people kind of get into a fight, too many drinks have been had, and an assault takes place. And each of these individuals, one lays a charge, the assailant then comes forward, and he must, first of all, take responsibility for the offence. He must then give the circumstances surrounding the offence. He must produce the circumstances which are his personal circumstances and why a prosecution and a potential conviction might hinder this offence. Then what he must do is he must be willing to submit himself to some sort of recompense to almost re-establish the balance of justice. In these instances, you normally would get referred to an anger management course, which you would have to complete through an entity such as NICRO, N-I-C-R-O. Alternatively, you'd be given a certain number of hours, 50 to 100 community service hours, and upon completion of those types of courses or hours, you almost get a reprieve from the state to say to you, you've demonstrated, you've taken responsibility, you've demonstrated remorse. There's no necessity to continue a prosecution with a potential conviction, which would ultimately hinder your abilities to be a productive member of society going forward.
But Lee, obviously that doesn't apply to all crimes, I would suppose.
No, I mean, you're not going to be permitted to do a diversion course if you're accused of murder and or alternatively rape. So it's minor type offences which don't necessarily tip the interest of justice in a negative fashion. So it follows on our rehabilitative elements in respect of sentencing. I mean, the idea behind sentencing, it must cover certain parameters, one of which must be aimed at rehabilitation of the accused or convicted individual. So it was a mechanism that was implemented with a view to, number one, affording people an opportunity to take responsibility, which is a fundamental that can't be missed. If you are going to apply for a diversion course, you must do so only on the back of the fact that you take responsibility for your conduct. So your conduct mustn't be so serious that it infringes the interest of justice to such an extent that it can avoid criminal prosecution.
All right. Excellent. Colleagues, we would like to know your views on something else that's a bit more, I would say, socioeconomic and jurisprudential, and not necessarily something that you face directly in your criminal law practices. And we are aware of the history of necklacing, as they called it in South Africa in the past. And what we have seen post the democratic dispensation is elements of that during some xenophobic attacks, and sometimes in communities there's mob justice. Basically the community taking the justice process into their own hands and meting out justice in whatever way that they feel would be appropriate. And we would like to know your views on that. What are the deep-rooted causes of that type of violent culture in our communities? Is it appropriate? How do we remedy it in our communities? Any takers? James,
I think I was going to say that from what we see, it's the way that the criminal justice system is portrayed in our media. It's as if that the losses are greater than the wins. Unfortunately, the kinds of matters that make it to media are high-profile matters, people who are known and all of those things, or somebody who has committed such a heinous crime that it made the news. What we don't see is what happens in the match courts, the kinds of wins and the struggles that are dealt with in the magistrates' courts. And as a result of that, it is the assumption that is made that the criminal justice system is not working because of one or two matters that we happen to see being displayed in the media. And as a result, people then make the choice that we know that when we go and report this case to the SAPS, somebody's going to buy or bribe the docket, and therefore we're not going to see any justice. And then as a result, they start committing the crimes themselves by saying that they are protecting their community, and they end up assaulting people and sometimes actually end up killing people. So what they don't realize is that as a result of committing the protection that they're saying for their communities, they end up themselves ending up having criminal records as a result of these things. So I think in order for us to try and circumvent such a position is to have more of the platforms such as these. But unfortunately, the people that need these platforms don't have access to the internet or Zoom or whatever the case may be. There are people at home who hardly have any income, who hardly have any knowledge of the platforms like this that are there. So I remember back when I was a student, we used to go into, it used to be a subject called street law back at the time. So what we would do, we would go into communities and actually teach communities what the law is, let them know about this and that. We even went to prisons as well to go, especially the juvenile prisons. We would go there and then have conversations with juveniles, especially the awaiting trial ones, so that they know they don't reoffend, especially if they're able to go through the NICRO program and all of those things, especially if the crimes that they committed were considered to be minor crimes. So this is the kind of knowledge that needs to be out there. We need to, if it's possible, again, for students to actually go back into the streets, and us who have the practical experience and knowledge, go back to the communities and have these kinds of conversations and educate them on their rights, so they know that if things go wrong, there is legal aid, there is SAPS, there is all of these things. And also maybe just educate our SAPS a little bit more on the criminal procedure and not just the SAPS Act, because that's also another problem that we are dealing with. That's just my 2 cents worth.
Thank you very much.
Can I just add one more thing to that? I'm sorry, I am now monopolizing this webinar. I apologize.
No, people.
Not at all.
I agree with everything that has just been said, but I think what is endemic in these situations is the fact that law enforcement to the highest echelons isn't making available the necessary resources to ensure that the law is kept up and enforced as it should be. You'll find that these instances of mob justice tend to take place in circumstances where the communities are not comfortably reliant on the South African police services to do their jobs and to prevent, investigate, and convict. So, speaking theoretically, and perhaps with a little bit of hope, the idea, to my mind, which would reduce the amount of people taking the law into their own hands, would be to ensure, and this is a function of government, that the persons that are lawfully permitted to enforce the law are provided with sufficient resources to do so. You'll find that complaints will be made in certain police stations of an incident which takes place, and the response that the complainant will get is, well, there aren't any vehicles available for us to attend at the site, so we can't go until the vehicle becomes available. And hours later, a police vehicle will stroll in, 2 members to come and attend at a site where a person has been murdered, raped, assaulted. So there isn't a sufficient turnaround in respect of the ability of the South African police services to actually do their job. Secondly, corruption is endemic, and so it's almost a catch-22. For so long as that the system allows for and doesn't prosecute and clamp down on corruption, we're going to find instances like this continuing in perpetuity. So to my mind, to add on to what was said, it's resources, making necessary resources available for law enforcement, and taking the necessary steps as against those law enforcement officers who find themselves guilty of offences.
Thank you very much. James, you wanted to come in? You are on mute. Hello, James, you are muted.
Yes. I just wanted to say what's effectively already been said, but to summarize, my sense of it is that people are desperately frustrated, whether their perception is accurate or not in respect of the criminal justice system is something which Lungelo rightly addressed. We need to bring to the attention of the general public that justice is being done. But unfortunately, we do need to add that justice is only sometimes being done. And the public is very well aware of that. And so when they capture somebody who they believe has committed an offense, they would rather take, I believe this is what driving it, they would rather take justice into their own hands than leave it to the chance that justice might be done. And there's a further driver here, which speaks to not only the lack of resources and proper processes within all of the criminal justice system, from the police and the investigation all the way through to a proper prosecution, which or at least let me say, sometimes fails, is that people are angry. And so it's a combination of their perception that justice might not be done, together with the anger that people are now living with very often in a society where they were promised a better future, and many, far too many are living in abject poverty, or certainly not in that brighter future that they were promised, and people are rightly angry.
Thank you. Thank you very much, James. Lungelo, Stephen, any comments on the previous question? I noticed that Stephen may have slipped into load shedding at the courthouse.
Turned off my video to hide the fact that I'm in darkness.
Good gracious.
Too much difference. But to add to that, look, it cuts both ways, because what the deficit in resources, what that means insofar as complainants and people want to report crimes and have some comfort that their complaints and problems are going to be attended to, and that they're going to get the protection from the police that they're constitutionally entitled to. It also cuts the other way. I mean, we've discussed earlier, several other panelists, to beating of suspects to get confessions and admissions out of them, improperly investigating things in a way that's infringes the rights of accused people as well. Most of us here are defense attorneys. I'm not sure if there are any prosecutors here, but the types of problems that these resource deficits mean for defense attorneys. I mean, as an article clerk doing after hours bail applications, when a suspect or an arrestee address had to be verified so that they could get police bail, and there being no available police cars to go and do that. Well, that obviously infringes his right to get bail, because while they have a right to verify his address and ameliorate the flight risk problem, he also has the right to bail, and that resource deficit hurts him. Insofar as investigations are concerned, often what happens is that investigations are done improperly. The corners are cut. Now, sometimes this helps us, sometimes it doesn't. Sometimes the forensic or the court process, which should test the investigative process and see whether or not the facts and the evidence that were obtained in the evidence are safe for the court to rely on, is seen to be too forgiving, or from a defense perspective anyway, too forgiving of the corners that are cut in light of the resource deficits. And then, of course, what I like to call systemic delay in the actual trial, pre-trial and trial itself. I've got a few trials on my roll, on my desk, where it has been going since 2017. I've got one that's been going for about 8 years now. So these things are serious problems for both complainants, for members of the public who want to be protected by the police, as well as as accused persons who might have been wrongly accused, who want to prove their innocence in court and can't.
Absolutely.
It's sort of we're failing to do what we should be doing, and we are also doing what we shouldn't be doing in our criminal justice system.
Thank you very much. Lungiano, I saw your hand.
My contribution is very short. In addition to the incompetencies that the policing system itself faces, we are also met with police officers who simply just don't want to do their jobs. Sometimes there will be a vehicle, but the police officer will give you excuses for why they can't go verify an address or do this or do the other. So it's a very frustrating system, and on both ends, that's just how I've experienced it. We are also met with police officers who just simply don't care enough to do something.
Thank you very much.
Elia, can I just jump in there quickly?
Please go ahead.
No, you can handle it, but I just want to alert you to it. In the chat box, there's a very fascinating question from Valencia, which talks about where the attorney is the one in the wrong, or the lawyer is the one in the wrong. Where the attorney gives you the wrong advice, the attorney is the one who. Can you see that question? It's the last one.
I can see it. So, colleagues, just to read out the question for you: can one hold the attorney liable for damages or prejudice suffered as a result of oversight or poor advice? To what extent can the attorney be held liable? Any takers, colleagues? Tabi saying you have unmuted yourself.
Yeah.
Sorry about
Tabi
that.
saying you want to
trying
go?
also yes, you can go, Professor, if you want. It's okay.
No, I just wanted to say I have a vague recollection of a few cases brought against attorneys on the basis of bad advice, where the court seemed to set the bar or the standard that needed to be proved against an attorney fairly high, at least on the basis that if the attorney was at least giving genuine advice in good faith, that they weren't held liable. And that's my recollection of it. And so what you really need to prove is, at the very least, as I understand or recollect from the case law, a form of gross negligence on the part of an attorney before our courts would impose liability on an attorney. But at least technically the answer is yes, of course. One may technically succeed against an attorney for grossly negligent advice. That's my recollection.
That's very true, Prof. I keep calling you Prof because I used to call you back in school. I'm so sorry.
No worries.
So the practical part of it, I think Lee and Stephen will probably know this. When you have a person who is not satisfied with what the attorney has brought in terms of advice and probably working the actual case, the first step is always to report that attorney to the Legal Practice Council, the LPC, and then you need to supply evidence as to why you are of the opinion that you were not given proper legal advice or legal service, and then the attorney is afforded the opportunity to reply to that allegation that is leveled against them, also with evidence either to counter, very much so to counter what has been said to them. And then the Legal Practice Council will then convene at some stage to then have a hearing, wherein in that hearing they now hear not only based on the papers that were submitted by both parties, but from both parties viva voce most times, and then they will make a decision whether or not the attorney was grossly negligent. If so, then they take the next step, either to suspend the legal practitioner from practice for a certain amount of time, or a warning, or have the attorney struck off from the role. So yeah, just a little bit of a practical additional info in that respect.
Yes, I must also add,
Yes.
in defense of the legal practitioners in attendance, I've heard a saying that lawyers think faster and the quality of the thoughts are better when there's money in the trust account. And the panelists can tell me if I'm wrong or right, but I think when members of the public come to legal practitioners for representation, it actually does help. And I think one of our panelists did indicate that in addition to coming for consultation, you should probably be able to pay for the bills as well. If you can do it in advance, even better.
Yeah.
James, you agree?
Absolutely. Just to add that perhaps it's worth the public knowing that if you can't afford an attorney, you are entitled to legal aid. And you should then approach legal aid if you're not able to employ an attorney and pay that attorney. And quite rightly, any attorney who you do approach will ask you for funds, or at least to commit to paying funds, although nowadays generally attorneys ask to be put actually paid the funds up front, in the form of what's called what can be called a retainer. But if you can't, there is a solution, and the solution is to approach Legal Aid South Africa.
Which then brings me to my next question, colleagues. Apart from having money in trust, what are the attributes that make a successful criminal lawyer? Over the years in your practices, what do you feel are the most essential skills or attributes that would make a successful criminal lawyer?
Lee, you want to go first?
Sure. So I think firstly you need to have a sound knowledge of the law. You're not going to escape the fact that you're going to need to deal with certain intricacies which may arise with more complex cases, white-collar crimes, admissibility of evidence. We were talking earlier about recordings. Those must be admissible in accordance with the ECTA, otherwise they're not going to find their way into proceedings. So you need to have a sound understanding and knowledge of the law. But practically speaking, fundamentally in my practice, I've found that you get things done a lot better when you've got good relationships and good rapport with the people with whom you work. You're not going to, your attitude will speak volumes. You're not going to get very far with anything if you've got a bad attitude and if your intention is to be as confrontational as possible on all occasions. So, the old saying, it's not what you know, it's who you know, rings true somewhat in the practice, I think, of most facets of law. So a sound knowledge of the law, I think you must have a very high level of integrity for yourself. You mustn't take on any kind of matter which would infringe or impugn your reputation, put you in, potentially cast you in a bad light. And your attitude and the manner in which you deal with the people in the system that you intend to operate in is also going to be fundamental. That's just my 2 cents on that.
Thank you very much.
If I may add, in addition to what Lee has mentioned, if there's one thing that was instilled in me in the time when I was a candidate, is paying close attention to detail. The smallest of thing could get either your client off or whatever. So good, the ability to pay attention to detail, for me, is one of the attributes of a good attorney.
Thank you very much. Any further contributions? I've seen a sentence that was not punctuated, and I think we might have seen this on social media. The same sentence is presented twice. In one format, it's punctuated. In another format, it's not punctuated, and the meaning is completely different. So that really speaks to paying attention to detail. How you write your affidavits or heads of arguments is very important.
For example, let's eat, comma, grandma.
Yeah.
And then let's eat grandma without a comma. Totally different
Yes.
implications.
Yeah. I think if I may,
Go ahead.
I think Lee touched on this, but it's something that needs to be said again and again. It's critical to maintain a amicable relationship and a professional relationship with your opposing parties, the advocate and the attorney on the other side. And often clients don't understand this, that you can go up and you can even enjoy a joke with, for instance, the prosecutor, and yet you go back and represent the accused. I've had accused ask me, how on earth can I be representing them and yet I'm friends with the prosecutor? And I've had to explain that there's a difference between my professional role and my where I'm representing them, and I'm perfectly able to argue their case. But at the same time, even professionally, I am required to maintain a civil relationship with the opposing side. And so much more actually gets done and achieved when you have a good relationship with the opposing party. And that's a critical thing for everybody to remember. Lawyers often like to adopt this confrontational attitude, or some lawyers, regrettably, adopt this confrontational attitude, and they in fact do a massive disservice to their clients when they do this, because of the fact that when you have a good relationship, you manage to resolve so many issues that don't have to be put in issue before a court. So you save time and money, and of course that's always a good thing. That's effectively what I wanted to say.
Thank you very much,
Yeah.
Jim. Ethan, please go ahead.
Am I unmuted? Oh, I didn't even realize. But I guess suppose to add to Professor's comment, when I was a candidate attorney many moons ago, I went into a courtroom here in Randburg Magistrates Court, and I had no knowledge how to address the magistrate, how to address I had no knowledge of anything. I was fresh from varsity. And upon introducing myself to the interpreter and the stenographer and the prosecutor, they're laughing at me when I told them that I have no knowledge of what I am doing. I don't know where to start. I don't even know what a guilty plea is, how to stand, all those things. What they chose to do for me, particularly the stenographer and the interpreter, was that they would have paper placards written there. So they would say, every time the magistrate would address, they would pick up the correct placard and then I would read out what is there. And as a result of that, I created the best relationships with the clerks, best relationships with the prosecutors, the interpreters, the court orderlies, such that when I walk into the Randburg Magistrate Court and get asked, what do you need? And then it's attended to so quickly. So it is so important to have those great relationships with people. And another thing that Professor spoke about, which hurts me a lot, especially when we deal with other matters apart from criminal, in civil matters, you have to engage your opponent in order to try and see if we can settle this matter as soon as reasonably possible, so that our clients don't suffer the consequences of paying exorbitant legal fees. But the second you get instructions and you pick up a phone and you call Advocate Malunga, I'm not saying you like that, Prof, but you call them and then you say, I'm on record, can we try and see how we can best advise our clients and come together with this? And you met such hostility, which then resonates also in correspondence. That for me is the sad part about our profession.
Absolutely. I must share as well that there's a tradition in the bar that after you finish a case, the losing party has an obligation to take the other advocate out for a beer and pay for the beer. And if you can't do that, and the beer is just something out there. But if you can't shake hands with opposing counsel, the case is done. it means one of you did something incorrect in court. Either stoop down to a personal level, or you deliberately misinterpreted the evidence, or in court case, you did something wrong, and that's why you can't walk out cordially out of court. Colleagues, the time is 13.
We've run out of time.
Yeah, the time is 30:34. I'm going to ask just one more question, and then we can close the session. And this one relates to maintenance orders and whether there are any criminal implications for failing to abide with a maintenance order. Any takers? Going once? Going twice? Anyone? The silence is deafening.
If I may,
I am sorry, I missed the question. I'm so sorry.
No, it relates to maintenance orders. It may be emanating from magistrate court or Rule 43, and someone refuses to abide by court order. Are there any criminal implications emanating from that type of conduct?
Yeah, the short answer is yes. Unfortunately, the Maintenance Act, I can't remember which section, criminalizes failure to comply with the maintenance order.
Thank you very much.
On that note, I'm under fairly severe time constraints. If I may be excused, I
No,
do
thank you
apologize.
so much, Stephen. Thank you so
All right.
much. We really thank you for your assistance, and I'll convey the message to Alison as well, who couldn't make it today. But it's wonderful. Thank you so much. And you've also shown us what happens in real time, the load shedding and everything.
No, on a serious note, the honor was mine to be amongst the type of co-panelists that have been here. It's a great honor. Thank you.
Our
Thank
honor.
you. Have a lovely
Our
day.
honor.
Kevin, if I may hand over to you, it's 13:36.
Are you done with the main? Yeah, unfortunately, thanks, Lydia. Unfortunately, we have a lot of other questions. The subject is big. It's a big elephant. There were questions, I think, in Namfundo about citizens' arrests, and it's a big initiative, and of course, we are very pleased with that in the sense that people are really asking practical questions. And thank you to my co-host, Advocate Dilia Mwanawina, and of course, thank you to all the esteemed panelists. We really appreciate this, and what we'd request, and there's no copyright over this. You can share it with your networks because it's an access to justice initiative. So the more this information goes out to people who can't afford this kind of information, the better. Because that's one of the reasons why we are having these webinars, and we have tried to make them as practical as possible. And of course, we aim to not only be strong on academic rigor. We want students who are well trained technically in terms of the LLB studies, but also who are also very practical in their knowledge of how the law actually works. And this initiative is helping us in this regard. And I just want to thank everyone. But before we go, I think any last comments any goodbyes from the panelists, and then we will close shop. Any last comments? No? Any takers? No? All right. Thank you.
Thank you, Kevin.
Thank you to our panelists, and thank you to my co-host. See you next time. Thank you. Bye.
Thank you very much.
Thank you so much.
Thank you, everybody.
Thank you. Thanks. Cheers. Bye-bye.
Bye-bye.
Bye.